And I think I'm live. Uh-oh, did I do it properly? Oh my goodness, it's hope it's not, hope it's on my channel. Oh my God, I gotta switch all these channels now. Anybody can hear this, let me know. I'll give you a minute or two, but I'm going to just start. No nonsense. Share my screen and just start so the people watching can continue. Entire screen. This. So basically, if you're just joining this, I just ended the last live stream. I couldn't squeeze it in because YouTube was going to shut me down. So I did the state's closing. Sorry, the state's closing argument. And then I did the defense closing argument. Now this is the state's rebuttal to the closing, and then the judge is going to speak, and then there's going to be like a 20-minute jury the jury's going to come back and do their announcement. Day 14 after this, so I'll make the titles accordingly. And I'm guessing, so I'm sharing my screen. I'll go full screen here. I'll update what I'm doing, and I'll take my. I'll just start sharing. Yeah.
All of the surveillance footage. We're going to give you all of that so you can look at that. We presented a couple of clips of those. They've presented some photographs of times. With everything that's been presented, he still has enough time. The 126 to 146 that we discussed, that full 20 minutes, that he was in the spray barn during that time. 341 to 429, they show a picture of potentially some farm implement out in a field and says he's the only one that could have been out there doing that. There was nothing to suggest that he was the only one that could have been out there doing that. We know Jaron was on the farm. We also know, based on their own witness testimony, Todd Nerick, that he was at the office, left the office when a little before the kids did. He goes out, does whatever he's doing, and he goes and meets Todd or the defendant at the spray barn. He says, I didn't go in the spray barn, but that's where Dale was. He didn't say he was out in the field planting or plowing or doing any of that. He was out at the spray barn. So again, we have that amount of time in the spray barn. 507 to 606. Again, he's clearly in there for that hour of time. There's additional time that he's in there that is, 5-10 minutes here and there. Granted, that's not a lot of time together, but you don't have to cut off the end cap all at one time. You can cut off 5 minutes here, 5 minutes there, but he has more than ample time to get this done. The defense talks about how the defendant knew that Ivan and his brother were in the old shop working on the vehicle that day. He sure did. He didn't take the welder out of the old shop. He went to the new shop when he needed a welder. He went in there and he grabbed the angle grinder and the discs, and he didn't take the tank into the old shop to weld it there because, number one, there's surveillance cameras in there. Number two, Ivan's in there. He also didn't take it into the new shop to weld it. Again, that's the other place that we've heard testimony the welding is done, the old shop or the new shop. He didn't take it into the new shop because, again, there are surveillance cameras in there. Where does he take it? He takes the tank and the welder to the one place on the farm that nobody welds, and there's no surveillance cameras. There's been an argument that the defendant takes no action to hide what he's doing on the farm that day. He is welding in the spray barn where you don't weld. Well, he could have been fixing this or he could have been doing that. Then why not weld where the welders are? He was absolutely hiding what he was welding when he took that to the spray barn. There was indication that he was criticized for looking over Zach Bach's shoulders when Zach was looking at the cameras. Again, the defendant is in and out of the office, seeing what's going on the surveillance. Would he want to know what's caught on camera? Absolutely. Is he looking for his wife? No. Was he looking for his wife when he tried to access the cameras at 8:48 and 8:49 that morning? No. What is caught on camera? Between 2:18 and 2:46, the sprayer moves from the front of the office and gets parked in between the surveillance camera from the office and the spray barn. So if you'll remember, he leaves the property, he's back by 2:18, he parks in front of the office, he goes in, talks to the kids, looks over their shoulder some more, and goes and moves the sprayer and parks it in front of that camera. The defense indicated that there was no single trace that Dee Warner was killed in the property. Think about what the medical examiner said. Those injuries don't necessarily mean she was bleeding out. She suffered multiple blunt force injuries. And the wording of it sounds awful, but he did indicate that did not mean that she was bleeding out. In the days after Dee Warner was last seen alive, Kevin Greca walked through the property on the 26th and observed things, made no indication of what types of searching he did or how hard he searched. But I will acknowledge that there's no big piles of blood. Again, medical examiner says, no, not necessarily. Doesn't mean you would see blood. The medical examiner cannot determine the exact date of death or the time of death. That's correct. This is not TV, right? What did he say? The way that they work in the medical examiner's office is they work with law enforcement to determine the facts surrounding the case. When was the last time anybody saw this person alive? The last time anybody saw this person alive was Dale Warner at 6 a.m. when she was snoring away on the couch, or Amy Alexander, who saw her at 7:40 the night before when she picked up Lena for the night. No duct tape, no tarp is on surveillance. Doesn't mean he didn't get those items. You guys went through the house. Could they have been in the garage? Could they have been in the attic? Could they have been anywhere else where surveillance may not have picked them up? Absolutely. He was in the spray barn while her kids were in the office. Again, with a grinder where that office is located. Those kids stayed in the office the entire time looking at the cameras to see if they could find their mom. With the location of that office, you're not going to hear that grinder. The paint. Justin Schmidt testified that the welding fairly quickly after you weld that, you could paint it. But he indicated the only spot that he saw that had paint on it in that photograph was that strip right around the weld, which is consistent with the paint expert who said you have layers of paint and then you have one additional layer of paint that's just under that weld, and that's the only spot on that tank that had that additional layer of paint. Where's the paintbrush? Where's anything that was used in the spray barn? The trash was taken out to the trash pile to be burned. Did you see that on the surveillance footage? You've got the tank on the far corner of the screen, and in the burn pit, you have a pile of trash from the spray barn. He continuously consented to searching all of his land again. Sure, come search. Not here, not now. You can search anywhere you want, but you can't search here. You have a right to say you don't want somebody to search. But when they come back later with a search warrant to search your property, and you come back onto the property and remove an item that is similar to the tank that her body is found in, again, a very unique tank, and you have come back to the property while the police are there searching. The dogs are 20 minutes out and you're 18 minutes, you're back and you're moving that tank and then you're gone again. Talked about the canine tracks. Again, what would that cadaver dog smell? Nothing. She's in the tank by the 25th at 6:39 p.m. So all the searches, all the canine tracks that didn't locate her, they were never going to locate her. The question was, where are the items that went missing from the home? The go bag, the purse, the phone, the wallet. Between Munger and Brooklyn, there's an awful lot of property. I don't have those phones, those go bags. I don't have anything. We were never able to recover any of those items. Again, your article search dog, the canine officer said, what do you say about finding those items? If they're outside in the elements, maybe 24 hours. When was the first search that they did of those properties? Not within 24 hours. Defense says, despite what Dreyer said on the stand, despite what he said, Dreyer said his statements were fairly consistent, which again was taken out of context. Yes, some statements were fairly consistent, but if you continue to read the report, Detective Dreyer went into the inconsistent statements. Defense claims that her client offered assistance in the background. He's got a 9-year-old that he's trying to take care of. The 9-year-old that he consistently throughout interviews said that he had never home, never had anything to do with her. I've got to work. I got a farm. My brother's got her. My brother's girlfriend's got her. What about Greg Hardy and some of the things he did? You mean like offering a reward for the return of his sister? Putting together all the search parties that walked out and looked for her? This defendant didn't go out looking for her. The defense stated, the defendant didn't really think suicide was a real possibility. That's one of the first things he brought up on 425 when Austin Hall gets there. She was talking about killing herself and taking off and leaving. And then the next day with Greca, what does he say? Yeah, my wife's depressed. 427, she's suicidal. She tried to kill herself once, 3 times throughout the course of our marriage. He is the one that brought that up first. He had to be prompted to talk about Mexico and Jamaica. Detective Dreyer explained why he asked that question, because throughout the course of this entire investigation, while his wife has been gone, he said numerous times, I'm 100% she's in Mexico or Jamaica. And it's because she thought it was beautiful there. The cartel. She's living with the cartel. Again, does it make sense that Dee Warner's getting on a $10 boat ride? During his interviews, the defendant acted like he didn't know why Dee stopped going to counseling. I'm doing everything I can to fix this marriage. She stopped going. I don't know why. I don't know what happened. Very clearly, in one of the text messages that you guys have, she says, I'm not going to Craig anymore. I'm the one doing all the work. I'm not doing it. I'm not doing it. There was testimony by people that Dale would rub Dee's shoulders. And when they were fighting, she was clearly uncomfortable with that. The Vinx device, that's going to be the tracker that Brian Bush testified about, that Stephanie Vocal testified about, and the defendant himself gave numerous statements about. Danielle Vanden Heuvel, the phone data expert, testified that that app was actually purchased by Dale Warner's device, but not downloaded. So he did purchase and not download. Brian Bush, he, when asked to describe his relationship with Dee, what'd he say? Depends on what the day was, Sometimes it was good, sometimes it was bad. His relationship with Dale was always like a father figure to him. There was a suggestion that the defendant didn't check OnStar when she was sneaking out because she didn't drive the Cadillac. Numerous statements he's given. She has never left here without a vehicle. And he wasn't allowing her to drive the Hummer because it took up too much gas, and the only place that she could drive it was out to the field to bring him food. Again, never brought that up to the police as a concern. My wife's been sneaking out. I don't know where she's been going. Stacy Brody testified twice before coming here, and she never once described the bruise as looking like a handprint. However, when she was shown her police report that her statement to the police that she made prior to ever testifying in any court, she clearly described that bruising as a handprint. The 23rd, when Todd says he's in the office and he gets into it with Dee and sees her in sweatpants, Stephanie was there too. She testified about that. What else did she say? I have never seen Dee Warner outside the house in pajamas or anything less than always dressed up. She always had to have the best on. The defendant was checking her phone location that morning. The argument is, if he knew that she was dead, why would he keep checking her phone location? He wouldn't keep doing this. No, you would, right? For the same reason that you would duct tape her mouth and nose, you don't want her to ever breathe again. I need to know that phone is not going to ever ping. I need to know that nobody's going to find that device. They talked about people roaming all over the property, yet we've heard Ivan Boyd and his brother were in the old shop. The entire family was in the office, and there were 2 employees that came into the old shop to clock in and clock out. They brought up Maddie's testimony that Dee would sometimes walk to the office. She had no socks and shoes on. Again, you've been on the property. You've heard the description of Dee Warner. She has never left her house in her pajamas and wouldn't be walking down to the shop without her socks or shoes on. April 27th, it was brought up, well, why wouldn't he just move the tank himself when law enforcement was there if they were going to come back? He didn't have to. He asked Jason Gravel to do it. Go back there and move that tank for me and put it in the spray barn. Again, what does Jason Gravel do? He moves the wrong tank. He did testify that it wasn't uncommon for him to move tanks, but what else did he say? That was the only time that the defendant has ever called me and asked me to put a tank inside the spray barn. The only time. The 27th, Parker Hardy goes in the barn, in the spray barn at 7 p.m. This is before tank 34 is brought in. Again, this is when the old rusty tank 8 is in there. Why would he notice the weld on tank 8? Tank 8 did not contain Dee Warner's body. Tank 34 did. And at that time, tank 34 was still over at the burn pit. Parker was the only person that saw the JCB tracks leading up to the house. Except for Dale confirms that he pulled the JCB directly up to the house and came back inside the house through numerous interviews. Again, Dr. Cho, the date of death, he testified he was not concerned at all that the date of death would be 4/25/2021. I said her body was kind of in pretty well preserved, doctor. Are you concerned about that? What do you say? No, there's no oxygen getting in that tank. The defense brought up that Dr. Cho said they could have been sweatpants. Again, Raquel looked at those photographs. She identified those as her mother's pajamas. Justin testified that cutting that end of that tank off would have been faster with a plasma cutter. Sure, of course. Why would you use that? Why wouldn't you use the plasma cutter? Well, what else did he say? If you want to weld it back together, it makes sense to use an abrasive cutting wheel. You don't use a plasma cutter if you plan to put that item back together. They can't match the chain or hook. Dee Warner was last seen on 4/24/2021, again by Amy Alexander, or 4/25/2021 by the defendant. And her body was not discovered until August 2024. Those items are gone. They went back and executed a search warrant after they found her body. The defendant says chemicals can cause burns. Sure. We had Ryan Rankin here talking about chemical burns. That burn was consistent with a welding burn, not a chemical burn. The fingerprints. The defense says the stickers were peeled off the tank when the paint analyst went to get paint scrapings. Who cares? The person who the fingerprint analyst was the first person to do anything with that tank. She came to Northville, dusted the tank, pulled the stickers off. So the stickers are going to be off before the paint analyst came and did her portion. So of course those stickers are going to be off. Look at the exhibit with the Google searches on it. It'll tell you the search term on there. The search term is chemical cremation. The items that were clicked were, why is it illegal? Chemical cremation, why is it illegal? There's no suggestion that he typed in why is it illegal. Go to that particular document and look what's in there. Chemical cremation. Where does he go? You know, when you type in something in Google and then you go down and pick the one you want and you click on that and read it, that's what that document is. Fingernail clippings were not sent to the lab for DNA. How many times did you hear that nothing inside that tank was suitable for DNA testing because of the chemicals? Detective Dreyer worked closely with the lab to try to get some of that stuff processed, and they could not be processed because the items were not suitable for testing. We didn't bring an expert in to tell you that the writing on the tag is the defendant's. I mean, look at the writing yourself. You've got plenty of documents. You're going to be able to come to your own conclusion on that.
Wow. Holy fuck. You hear that?
There was a suggestion that Terry and Todd weren't spoken to, that none of these people were looked at or talked to. That's simply not true.
When were they spoken to? Just gonna say it's not true.
And finally, the defense indicates that if this crime was premeditated, he would have had all those items already. They would have been ready for him to go, ready for him to cut that off, ready for him to do the welding back. Again, premeditation, deliberation, they do not take that long. I don't have to think about it, go plan it, go pull my welder in and then go kill her and then weld her up, right? We talked about the yellow light. When you see a yellow light, or you think, what do you think? You've heard about her injuries. 1, 2, 3, 4. How many chances did he get to think about it? Then she was strangled to death. 5. How many chances did he get to think about what he was doing? And then not only that, let's assume 3 or 4 knocks her out, 5, she's unconscious. What do you do? Call for help, right? I screwed up. I hurt my wife. Come help. This defendant duct taped her mouth and her nose so that she could not breathe again.
Whoa.
Those were all conscious decisions.
There's nothing on this duct tape.
1,
2, no fingerprints.
3, 4.
No, nothing. Just
Every
a theory.
one of them.
They found black duct tape in his garage.
You
No
will
match.
have the surveillance footage. You will have
You don't.
every piece of evidence that's been
Watch
presented.
it.
Anything
Watch
you
the
want to look
surveillance.
into further,
641,
look at it. Ask for it.
642, 643.
we want you to look at it.
I want you to show us.
We want you to return a
642,
verdict of guilty
1202. Where is
first-degree
it?
murder and tampering
Find
with
it.
evidence.
I dare you. It's not there. It's fucking. She showed you nothing. A safe. Nothing. Not one piece of evidence this whole trial.
All right, ladies and gentlemen of the jury, we do have a procedural step that we need to take care of outside of your presence. So at this point, I'm going to ask you to return to the jury room. We'll take a short break. We'll come back. I'll give you the final instructions.
And I will just go ahead. I will go ahead. Such gobbledygook. She said nothing that whole closing. Nothing. Dare you to find some evidence in her closing. And yeah, there's no fingerprints on it. There's none of this guy's hair stuck in this duct tape. They can't even, when they rip it, they can't even match the rip up to the duct tape. They found duct tape in his, on his farm, and there was tools everywhere. So it's about to start. Let me get the right heading up here. The right highlighted comment. Which one was it? Shit. Oh, actually, the judge is just going to speak now, so I'll just put his any second now. Here he comes up, and then it's going to end, and then I'm going to skip to the verdict one, because the verdict one is they just interrupt their newscast or their forecast on the news. So I'm just going to hit full speed 2x. They have it muted. It's going to come up any second now. The judge is going to speak. It's like 5-10 minutes or so. Maybe 20, maybe 15 minutes. I'm not sure exactly. Then it's going to end, and I'll play day 14. Sorry, I couldn't squeeze it in. I had to shut it down, start a fresh one, because YouTube only does 11 hours and 55 minutes. And then I could stream longer, but it doesn't show it on YouTube. It just ends it. So should be any second now. When the volume kicks in, they'll be standing up. Man, literally, I swear to God, worst closing ever. Her videos, she doesn't show nothing. It's all just theoretical and narrative. I just sped it up a bit. They literally showed nothing. Prosecution, I swear to you. Yep. Judge is going to speak. I'll be quiet now. And then afterwards, it'll be the verdict. It's really quick. It's like 15 minutes. They deliberated all day, but at the very end, they must have just rushed in and caught everyone off guard. Day 14. Oh, and there's that whole thing with the judge sent the alternates home on the Thursday. Then on the Friday, they had an emergency. They needed the alternates. The alternates went and talked to their family on YouTube and watched stuff. And then he had to interrogate them. And then there was an emergency. And oh, my God. Then they had Monday off. And then the Tuesday, they came back and they deliberated. And all day long, the live stream was blank. And then right at the end, they just came out with their verdict. So on normal speed, I'm just going to leave it. Because, man, worst closing ever.
To bring the jury back in.
Yes, Your Honor.
Sure,
Yes.
sure. Like, you watch that prosecutor's closing statement, the first part of it, she shows you everything she's saying. She's not showing you in her videos, in her screenshots of videos. Drew, you even said that makes sense now. How he said Ivan borrowed the JCB to throw the garbage out. She implied that the person that threw Ivan's garbage out threw the tank there too. It's literally in their closing. It's amazing how this is like, if he did it, it wasn't like this. I'm not saying he couldn't have or didn't or wasn't involved, but it was not like the way they said it. They didn't show you nothing. Man, she almost set this guy free, literally. This jury was like, oh my God. They almost let him go, I think.
Members of the jury, the evidence and arguments in this case are finished, and I will now instruct you on the law. That is, I will explain the law that applies to this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors, who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of the case are. This is your job and no one else's. You must think about all of the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I have already given you some instructions about the law. You must take my instructions together as the law that you are to follow. You should not pay attention to some instructions and ignore others. To sum it up, it is your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way, to decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Each crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. A reasonable doubt is a fair, honest doubt growing out of the evidence or the lack of evidence. It is not merely an imaginary or possible doubt, but a doubt that is based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. Likewise, the fact that he is charged with more than one crime is not evidence. The lawyer's statements and arguments are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept things that the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses, your questions to the witnesses, and my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to the case. However, when I make a comment or give an instruction, I am not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide the case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decisions only on the evidence that I let in and nothing else. Questions and comments made by law enforcement during the defendant's interrogation and interviews are also not evidence. You should consider those questions and comments only as they give meaning to the defendant's answers. Your decision should be based on all the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you have about a place, person, or event. To repeat once more, you must decide the case based only on the evidence admitted during this trial. If you want to communicate with me while you are in the jury room, please have your foreperson write a note and give it to the bailiff. It is not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you may take your notes and the full instructions. If you want to look at any or all of the reference documents or exhibits that have been admitted, just ask for them. When you go to the jury room, you will be given a copy of the instructions you have just heard. As you discuss the case, you should think about all my instructions together as the law that you are to follow. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So, for example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence. Circumstantial evidence by itself, or a combination of circumstantial evidence and direct evidence, can be used to prove the elements of a crime. In other words, you should consider all the evidence that you believe. As I said before, it is your job to decide what the facts of the case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness says. You are free to believe all, none, or part of any witness's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have and not be influenced by a witness's disability, gender identity, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. Again, take the time you need to test what might be automatic or instinctive judgments and reflect carefully on the evidence. There's no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth? Or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age, maturity level affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how the case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all of the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think that someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in this case. However, you may conclude that a witness deliberately lied about something that is important to how you decide this case. If so, you may choose not to accept anything that witness said. On the other hand, if you think that the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. You have heard evidence that before the trial, witnesses made statements that may be inconsistent with their testimony here in court. You may consider an inconsistent statement before the trial only to help you decide how believable you think the witness's testimony was when testifying in court. If the earlier statement was made under oath, then you may also consider the earlier statement as evidence of the truth of whatever the witness said in the earlier statements when determining the facts of this case. You should not decide this case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You have heard that a lawyer or lawyer's representative talked to one or more of the witnesses. There is nothing wrong with this. A lawyer or lawyer's representative may talk to a witness to find out what the witness knows about the case and what the witness's testimony will be. You have heard testimony from a witness, Dr. Patrick Cho, who has given you his opinion as an expert in the field of forensic pathology. Amanda Isett, who has given you her opinion as an expert in the field of fingerprint analysis. Michelle Ponchke, who has given you her opinion as an expert in the field of paint analysis. Justin Schmidt, who has given you his opinion as an expert in the field of welding fabrication, inspection, and certification. And Jordan Graves, who has given you his opinion as an expert in the field of digital media forensics. Experts are allowed to give opinions in court about matters that they are experts on. However, you do not have to believe an expert's opinion. Instead, you should decide whether you believe it and how important you think it is. When you decide whether you believe an expert's opinion, think carefully about the reasons and facts they give for their opinions and whether or not those facts are true. You should also think about the expert's qualifications and whether their opinion makes sense when you think about all of the other evidence in this case. You have heard testimony from witnesses who are police officers. The testimony is to be judged by the same standards you use to evaluate the testimony of any other witness. You have heard evidence that the defendant engaged in stalking behavior and domestic violence. He is not on trial for those acts. Before you may consider this evidence against the defendant, you must first find that the defendant actually committed those acts. If you find that the defendant did commit the acts, you may consider them in deciding whether the defendant committed the offenses for which he is now on trial. You must not convict the defendant in this case solely because you think he is guilty of other bad conduct. The evidence must convince you beyond a reasonable doubt that the defendant committed the offenses for which he is now on trial, or you must find him not guilty. Every defendant has an absolute right not to testify. When you decide the case, you must not consider the fact that he did not testify. It must not affect your verdict in any way. The prosecution has introduced evidence of a statement that it claims the defendant made. Before you may consider such an out-of-court statement against the defendant, you must first find that the defendant actually made the statement as given to you. If you find that the defendant did make the statement, you may give the statement whatever weight you think it deserves. In deciding this case, you should think about how and when the statement was made and about all the other evidence in the case. You may consider the statement in deciding the facts of the case. The defendant is charged with 2 counts, that is, with the crimes of open murder homicide and tampering with evidence. These are separate crimes, and the prosecutor is charging that the defendant committed both of them. You must consider each crime separately in light of all of the evidence in the case. You may find the defendant guilty of all or any one of these crimes, or not guilty. The defendant is charged with the crime of first-degree premeditated murder. To prove this charge, the prosecutor must prove the following elements beyond reasonable doubt. First, that the defendant caused the death of Deanne Warner, that is, that Deanne Warner died as a result of blunt force trauma and or strangulation. Second, that the defendant intended to kill Dee Warner. Third, that this intent to kill was premeditated, that is, thought out beforehand. Fourth, that the killing was deliberate, which means that the defendant considered the pros and cons of the killing and thought about and chose his actions before he did it. There must have been real and substantial reflection for long enough to give a reasonable person a chance to think twice about the intent to kill. The law does not say how much time is needed. It is for you to decide if enough time passed under the circumstances of this case. The killing cannot be the result of a sudden impulse without thought or reflection. You may also consider the lesser charge of second-degree murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Deanne Warner, that is, that Deanne Warner died as a result of blunt force trauma and or strangulation. Second, that the defendant had one of these three states of mind. He intended to kill, or he intended to do great bodily harm to Deanne Warner, or he knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of his actions. You must think about all the evidence in deciding what the defendant's state of mind was at the time of the alleged killing. The defendant's state of mind may be inferred from the kind of weapon he used, the type of wounds inflicted, the acts or words of the defendant, and any other circumstances surrounding the alleged killing. Premeditation and deliberation may be inferred from any actions of the defendant which show planning or from any other circumstances surrounding the killing. The prosecutor need not prove a motive for the killing, but you may consider evidence of motive in deciding if there was premeditation and deliberation. Motive by itself does not prove premeditation and deliberation. The defendant is charged in count 2 with tampering with evidence. The defendant is charged with intentionally removing, altering, concealing, destroying, or tampering with evidence to be offered in an official proceeding. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that there was some evidence to be offered in a present or future official proceeding. An official proceeding is a hearing held before a legislative, judicial, administrative, or other governmental agency, or a hearing before an official authorized to hear evidence under oath, including a referee, a prosecuting attorney, a hearing examiner, a commissioner, a notary, or another person taking testimony in a proceeding. Second, that the defendant removed, altered, concealed, or otherwise tampered with that evidence. Third, that the defendant removed, altered, concealed, destroyed, or otherwise tampered with that evidence. He did so on purpose and not by accident. Fourth, that the evidence that the defendant removed, altered, concealed, destroyed, or otherwise tampered with was used or intended to be used in a criminal case where open murder homicide was charged. The prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about April 25, 2021 within Lenawee County. You may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecutor does not have to prove that the defendant had a reason to commit the alleged crime. She only has to show that the defendant actually committed the crime and that he meant to do so. The defendant's intent may be proved by what he said, what he did, or by any other facts and circumstances in evidence. Possible penalty should not influence your decision. If you find the defendant guilty, it is the duty of the judge to fix the penalty within the limits provided by the law. When you go to the jury room, you will be provided a written copy of these final jury instructions. You should first choose a foreperson. The foreperson should see to it that your discussions are carried out in a business-like way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communications equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It is your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and your reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide that you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. If you have any questions about the jury instructions before you begin deliberations, or questions about the instructions that arise during your deliberations, you may submit them in writing in a sealed envelope to the bailiff. I have prepared a verdict form that lists the possible verdicts. So at this time, ladies and gentlemen, we will ask you to return to the jury room and begin your deliberations. As I said earlier, I apologize. So Ms. Escott, we do need to draw our jurors who are the alternates that will be excused at this point.
Right, they have a little lottery here and pick them out of a hat.
I will call
And-
4 jurors who will be excused at this time. I will refer to you by seat number.
And there's going to be an emergency tomorrow. They're going to need some
And ask
jurors,
that
alternates.
If you are excused, that you come out through the door that you've been coming in and out of.
Because on Tuesday, when they come back to deliberate and give their
Juror
verdict.
in
Oh, my
seat
God.
number 11 will be excused by stipulation of the parties.
Bingo. B24.
Seat number 5
Bingo. Monday got bingo. Nicole, you're next. Get ready.
seat number 14
Mushroom bingo for Nicole.
seat number 2
Bingo.
Right, we will give them a moment to collect their things and to collect their notebooks. In the meantime, Madam Clerk, would you please swear the officer? Oh, I'm sorry, I apologize. So we'll need Deputy Esposito to come back.
all right.
DD, bingo. Yeah, Monday.
Now, Madam Clerk, would you please swear?
He's
the
in no
officer?
mood to play
Raise your
bingo.
right hand. Do you solemnly swear that you will, to the best of your ability, keep the persons sworn as jurors in this trial from separating from each other, that you will not permit any communication to be made to them or to any of them, orally or otherwise, that you will not communicate with them or with any of them, orally or otherwise, except by the order of this court, or to ask them if they have agreed upon a verdict, until they shall be discharged, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they've agreed upon.
At this point, ladies and gentlemen, we will ask you to return to the jury room and begin your deliberations.
Look at that fucking guy.
All right, is there anything that either side would like to address on the record at this point?
No, we would like a side-by look.
Okay, yeah, you can't approach.
You may see.
He's whispering pretty loud. Who's whispering? I fucking hear them. I should call. I turned closed captioning on. They're talking pretty loud, eh? He forgot his mic's on. I bet. Someone's mic's on. Man, no evidence at all. They made it all up. It's circumstantial. The JCB, they pulled it up and parked it in front and extended the boom. I can hear you. I can hear you guys. We can hear you. Oh. I see dead people. Oh.
All right, so process-wise, what we will do is allow the jury to deliberate today until sometime between 5:30 and 6 o'clock, which is normally what I do when we get to this point in the day. There are some issues that need to be resolved in the event that the jurors ask for certain exhibits, and it's my understanding the attorneys are going to work on resolving that now in terms of how to put those in a format that the jurors will be able to work with.
That's correct, Your Honor. That's correct. Thank you.
All right. We will be in recess then.
So I'll skip ahead because I've already seen this. Nothing happened. And I even know the next one here is this one. I already have it ready to go. So look at this is the next day. So they deliberated the rest of that day, nothing. And then they came in on the Tuesday. So that was a Friday. So I had Monday off. They came on a Tuesday. And look at the first 6 hours and 53 minutes. They did literally, people were just, the jury was there deliberating. And all of a sudden, when they come in, it's like they interrupt their newscast or something. Watch the guys like doing the weather. Watch this. I'm going to play it too. So I'll take this off. So it's going to be this coming up. And when it starts, I'll take this back off. So this is day 14. So this is what happened on their live stream. So after you got a picture, this is the Tuesday. So the Thursday, the judge sends the alternates home without instruction. Then they got that night, they start looking at YouTube and searching the internet and talking to their family, people, friends. And then on the Friday, they had an emergency and they needed an alternate. So they called them back and started interrogating them, and because finding out which, oh my God, it was amazing. So I wonder if they're going to show any of that or not. I don't think they will. Let's see. This is just the ending. Where is all that jury stuff? Did I miss that? Do I bother playing that or what? Because it was part of the trial. Why do I feel like I've missed it? I feel like I caught it on my first time I watched it. There's a whole bunch of jury stuff. You know what? What do you think I should do? Just play this or actually show you the, hey, what's up, Ferb? FBD, what are you doing? Where you been? Is that our FBD, Ferb Baby? I don't even recognize your name anymore. Ferb Baby Daddy. Is that our guy? Oh, where you been? Let me just double check because I thought I had a playlist for the jury stuff because they interrogate. You know what? I'll just play the trial and I'll catch it later. We'll just go over stuff because there's a whole jury dilemma, and then the judge interrogates them on that Friday, and it's not even that interesting. So I'll play it afterwards. Here we go. Day 14. The jury's deliberating all day, and then this happens. Everyone thinks they're ready to go home. It's like the 7th hour. It's got to be like 5 or 6 in the afternoon, 5:30 or so. And then this happens. They're like, whoa, the jury made a verdict. Caught everyone off guard. So I'll speed it up a bit. But when it comes on, when anything happens, I think they interrupted their newscast. Watch. Their live stream or something. There was something else that happened. Like the guy was doing the weather or something. It's W2 here. Something happens soon. So, Dee Dee, is that our FBD? What do I say to him? I'm so nervous. I forget. I haven't seen him in so long. Where you been, Pickle Man? You've got to be the right one because you got a wrench. So it's my buddy. Oh, where you been, dude? You missed this whole. I've done this trial twice. 2 times. It is. I know. He's got a wrench. I see it now. It's my pickle boy. My favorite pickle. Furry pickle. Here it comes. Watch this. They're going to interrupt the news right here. This guy's doing the goddamn weather forecast soon. Coming up here soon. I saw it somewhere. It's like caught everyone off guard. People were probably half asleep, thinking, oh, let's just go home. And the jury comes in with the verdict. So like this was their live stream on that day. Like they literally started it and they played it for like 7 hours straight, just showing the seal, the state of Michigan seal. Let's speed it up a bit. It's going to be any second. So it's 2x. Here it comes. Verdict. It's only like 10 or 15 minutes. Sure caught everyone off guard. I took that picture in the 90s. I've been hiring now. I'm back. Oh, right on. Well, come say hi more. Here come. Oh, that was David Lee Roth, I think, or the singer from Skid Row, Sebastian Bach. It looked like. Oh, I sped it up again. I swear I saw them break in on the weather forecast. Oh, it's going to be any second. So close. Dude, you got to watch this playlist. I've made this play. So if you want the shenanigans, you watch my other playlist because I could only get 2 days done each live stream. But when I did this last time, I did it again and I did it with no shenanigans, very little interruptions. And I was able to do 3 full days worth of one live stream. So say I did 10-hour live streams, right? The first day I could only squeeze through like 2 days, which were 8 hours each day with breaks. This time I did 3 days worth of 8-hour show like breaks through a 10-hour live stream because I didn't talk so much or shenanigans. No shenanigans. Serial Shibby. Here it comes. I feel it. Oh my God. wonder if they're gonna say not guilty this time.
We'd update you throughout the weeks and the months on WTOL 11 Plus. We're awaiting the verdict to be read in the Lenawee County courtroom. We'll be back right after this.
Psych. Watch this. They're gonna show the guy doing the new weather. I thought that was a black dude doing the weather. Watch. He's like, what? Could have sworn I saw it. Maybe I didn't. What am I doing? Let's see. Or afterwards, they go to it then. That's what it is. Afterwards, yeah, there it is. The guy's doing the weather. So, what it is they throw it to their live people afterwards because they're all shocked. Okay, I'll show you. They've muted it again. But look at my thumbnail thing. So the judge speaks for 10 minutes, and then everyone's shocked. And look at they break into their live like headline news, and this guy's doing the weather here. He's like, what? Nobody can believe it just happened, but they break into the weather. There. Oh, I had it. Oh my God. Oh, show me the weather. I had a couple. There it is. I keep seeing it. It's like one thumbnail. Where are you, weather? Oh, I can't get it. Oh, there it is. I got it. It's like a tornado watch. 6:42 p.m. on. I can see it. Or 5:42 p.m. in their thumbnail. And they're all like, what? It's got to be any second now. They're breaking in. Yeah, it's like so close. I'm not going to mess with it. Actually, I'll just go to speed it up a bit. As soon as I hear the sound, boy, oh boy, I'm going to have to go back to 1x.
That we had received word in Lenawee County, the Adrian courthouse there, that there has been a verdict reached in the Dale Warner murder trial.
We got word that there was a verdict around 4:40, so just about 4 minutes ago. Oh, as you can see right now, they are actually bringing back in Dale into court. This is a live look right now of the courthouse.
Left side of the screen.
You can see Dale sitting down waiting for this verdict. Again, we're only about a few seconds away from having this verdict read from the jury. This is 8 hours after deliberations. We are going to listen to see if the judge is going to comment and wait for this verdict to be read from the jurors.
Yeah, real interesting dynamic that unfolded over the weekend. Well, we're going to let you listen in.
Session, the Honorable Michael O'Sayer presiding. You may be seated.
We understand that they invited the family, got that. We'll let you listen in.
1841-FC, People versus Dale Warner. It's my understanding at this time that the jury does have a verdict. A couple of things to address on the record before we bring the jurors in. First is that we did Friday, I spoke with the attorneys, they agreed that rather than bring the jury back into the courtroom, the court would just read the publicity instruction to them in the jury room, and did that. We've also had several questions from the jurors. I had discussed those with the attorneys. We agreed on a response, and that was given to them in a response on the note that they had passed to the court. Is that all accurate, Ms. Watts?
Yes, Your Honor.
Ms. Sharkey?
Yes, Your Honor.
All right. At this point, we will be bringing the jury in to deliver the verdict. But first, I would like to say that the jury has spent more than 5 weeks being selected, listening to testimony, and deliberating on this matter. They have shown a great commitment to our system of justice. They are going to render a verdict, and that is their job. I will not allow them to be subjected to any disturbance. This matter is very important, obviously, to the people of the state of Michigan, to Mr. Warner, and to Ms. Warner's family. Regardless of what that verdict is, I will not tolerate any outbursts, remarks made, or otherwise undignified behavior. If that does occur, the person responsible will be removed from the courtroom, or depending on the severity, taken into custody, and there will be contempt proceedings to address any violation of this order. Everyone must maintain control of their emotions. If you do not, or you do not think you'll be able to, you should take this opportunity to step outside of the courtroom. Because again, I will not subject the jury to any form of harassment. All right, are the people ready to receive the verdict?
Yes, Your Honor.
Defense ready to receive the verdict?
Yes, Your Honor.
Okay, once again, live here in the studio as they bring the jurors back in. Obviously, our cameras are not going to show that. But the one thing I was alluding to before the judge started speaking here, Kaylee, is we had an interesting dynamic play out Friday when one of the jurors having an emergency did not know if that juror was going to return. The jury has now been seated.
Let's hear this verdict from the jury.
You may be seated. Thank you. Ladies and gentlemen of the jury, would the foreperson of the jury, without telling me what the verdict is, let me know whether in fact you have reached a verdict?
We have, Your Honor.
Would you pass that to the bailiff, please? Madam Clerk, would you please read the verdict?
Members of the jury, listen to your verdict as recorded. You do say upon your oaths that you find the defendant, Dale Warner, as to count 1, guilty of second-degree murder. As to count 2, guilty of tampering with evidence. So say you, Mr. Foreperson.
I do.
So say you, members of the jury.
Would either the people or the defense wish to have the jury?
Yes, please, Your Honor.
Madam Clerk, would you please poll the jurors?
I will call you by seat number as you are seated in the jury box. If you agree with the verdict, you will say yes. If you disagree with the verdict, you will say no. Seat number 1.
Yes.
Seat number 3.
Yes.
Seat number 4.
Yes.
Seat number 6.
Yes.
Seat number 7.
Yes.
Seat number 8.
Yes.
Seat number 9.
Yes.
Seat number 10.
Yes.
Seat number 12.
Yes.
Seat number 13.
Yes.
Seat number 15.
Yes.
Seat number 16.
Yes.
Thank you.
Ladies and gentlemen, I want to thank you once again for your service in this matter. As I indicated at the outset of the trial, jury service is one of the most important functions that members of a free society are asked to perform. At this point, I will excuse you to return to the jury room. If you wouldn't mind, I'd ask you to wait there for a few minutes and have some additional comments I'd like to make in private. You can be seated. At this point, the court does need to set a sentencing date, and the first opportunity would be May 7th at 8:15 a.m. Does that work for the people?
I'm sorry, Your Honor, what time? May 7th at 8:15, you said?
Correct.
Okay, thank you.
The 7th and then through the following week do not work for me.
All right, so through the following week,
Correct.
so that would put us out to May 28th would be the next available opportunity.
That would work.
I'm scheduled to be in a trial in Macomb.
Okay, would that be the 29th as well?
Yes,
How about June 4th?
unfortunately, I'll be out of the country.
And when would you be returning?
I could be back for June 18th.
All right, that week does not work with the court schedule, so we'd be looking at June 25th.
We're in trial in Calhoun.
If May 7th works, I can make May 7th work. Does that work
Okay.
for you?
Yes, it does.
Okay.
Okay. So May 7th then at 8:15 a.m.
Thank you, Your Honor.
Thank you.
Is there anything else that we need to address on the record this afternoon?
No, thank you.
No, thank you, Your Honor.
All right. Thank you all for your time then. The court will be in recess.
Your Honor, may we briefly approach? Thank you. Okay. Okay, great. So we'll leave. Okay, great, thank you. Okay. So we'll leave it here.
We're making our eye view through some of the Hardy family there, and I don't know if you could pick that up there at home, but you heard the click of the handcuffs going back on Dale Warner's hands as he is taken away by Lenawee County Sheriff's deputies. The door closes, and obviously it shuts the door on what just transpired. So obviously, let's talk a little bit through what we just heard, what we heard the jury say, what we heard the judge say.
Again, if you are just now joining us, you just heard the verdict for the Dale Warner murder trial. This is about 3.5 weeks of witness testimony, 8 hours of jury deliberations. You are seeing right there some of the family of D. Warner. Dale Warner found guilty of second-degree murder and also guilty of tampering with evidence. The interesting thing here in Michigan, the difference between first-degree premeditated, if Dale had been found guilty of first-degree premeditated murder, he would face a mandatory life sentence without the possibility of parole. But since he's been found guilty of second-degree murder, he does still face life in prison, but with the possibility of parole. but it is still going to be about 2 months before we are even at sentencing.
Yeah, you heard them kind of go back and forth on dates that would work, dates that wouldn't work. It'll be interesting. Our Melissa Andrews has been covering this since day one. She will obviously have some interviews done with the Hardy family, the rest of the family that has been outspoken during the course of Dee's disappearance. I'm curious to hear from them. You obviously push for the max as far as the family members were concerned. And I wonder if they will be satisfied with this verdict.
You could see, too, that I know that I saw Greg Hardy get a little emotional there and the rest of the family hugging afterwards. I mean, for them, yeah, this has been, next month will mark 5 years.
And we're back. I'm just going to shut her down. Where is this last comment? Here it is. This is for you, lovely Nicole. I dedicate this to you. Shibby, is it what? Is it Max? What did you say? No, well, kind of. Yeah, sort of. Well, it's better. It's better. You've seen a lot of Max. Here, this is for Nicole. I'm just going to shut her down. I'll come back tonight, especially if Ted doesn't ask me to come on or something. I'll come back on and we'll go through this. If Nicole finds the docs, I'll read them. But I got a lot I could rip apart with this. I could loop and loop over that video. We can have some fun. We could start a new trial. I don't want to make light of this, but man, I could loop and loop over this because it's so goddamn ridiculous what just happened. Anyways, here we go. Nicole, this one's for you. I'll see you guys tonight. I'll make a new live stream after this. And bye, Nicole. Enjoy this for you, okay? Bye. Your favorite.
25 ways to say shibby. 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 Oh, shibby. I'm so shibby. Yeah, I'm well shibby, ain't it, bruv? Shibbiest shib in the world. As shibby as shibby can be. Shibby. 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 Shibby? Shibby. 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 Can we just stop on the shibbying? How many have we done? I don't know, about... I don't really know. I haven't counted. Me neither.